Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding the answers to our elder and estate planning questions. I'm your host, Mary Ravazio, and joining me are Mike Smith and Richard Barid of Smith Barid LLC. Mike and Richard both live in the Savannah area, and they are licensed to practice law in the state of Georgia, where they focus their practice exclusively in elder law and estate planning. Hello, gentlemen, and welcome to today's Elder Care Answers.
Hi, Mary. It's great to be here.
It is. Thank you.
I'm curious. There are so many areas of law you could have chosen to practice in. Why elder law and estate planning?
Well, Mike and I first met in law school at UGA in Athens, and after we graduated and passed the Georgia bar, we worked at different firms for about 10 years, but neither of us were really happy, and more importantly, we both felt a calling to help people.
To us, the most effective way to help people is helping them prevent problems before those problems happen, which is why we create effective estate plans and long-term care plans to protect our clients and their families.
So, Mike, since you work with many clients in all aspects of elder care and elder law, what's the most common question your clients ask?
Well, that's an easy one. The most common question we get is, how do I keep from going broke if I need expensive care?
You mean if they have to go to a nursing home?
Well, that's usually what they mean, but that's only because they don't realize that other care, like home care or assisted living, is also very expensive.
So this sounds like something we need to make sure we clearly explain. Let's start with nursing home care. Richard, how much does it cost and how do we pay for it?
Okay, so what most people refer to as a nursing home or maybe a rest home is technically called a skilled nursing facility, and in our area of Georgia, that's usually at least $6,300 per month for a semi-private room, which is a surprise to most people if they don't have any experience with that type of care.
Well, that definitely explains why people come to you to find out how to avoid going broke in a nursing home.
Yeah, sadly it does. The thing is, people don't seem to understand that they can avoid going broke in a nursing home if they plan ahead.
How so?
Well, first, they shouldn't wait till they have a medical diagnosis or even symptoms of an illness to begin to plan. And even with our best efforts, sometimes we just can't avoid illness, falls, or other types of accidents, so we need to be prepared for all of those things.
Well, that makes sense. So when do we begin to prepare for the bad things that can happen to us?
Every adult should at least have the basics of estate planning, what we commonly refer to as your foundation.
Okay, a foundation. What are the basic building blocks that make up the foundation of an estate plan?
Well, it's really a handful of documents, and I'm sure many of our viewers believe they have what we're calling a foundation. But this next point is really important. Not all foundations are created equally.
What do you mean by that? I mean, isn't a will just a will, and aren't they all pretty similar?
No, they're not. Here's the issue. Years ago, people didn't usually live a long time with an incapacity or illness, but now they do. Because of longer lives, increased litigation, and the focus on privacy rights over the last couple of decades, it isn't enough to have basic, generic estate planning documents. The documents also need to include provisions to address these issues. We call them elder law and disability provisions.
Okay, so what documents should be in my foundation, and exactly what elder law and disability provisions should be in my foundation?
Your foundation should include a last will and testament, a durable power of attorney for financial decisions, and 2 medical documents, which are an advance directive for health care and then a HIPAA authorization and release.
So most of us know what a last will and testament is, but what elder law and disability provisions should be in that?
A good will should provide for a beneficiary who might be disabled. For example, what if the healthy spouse dies unexpectedly before the less healthy spouse? That spouse will now need outside caregivers to come into the home, might even need a facility. And that's just one example where it probably would have made sense to have the option for part of the estate to be held in trust for the benefit of the surviving spouse, just in case it's needed.
That's interesting. So what about other beneficiaries, such as the children? They wouldn't benefit from those provisions in their parents' will, would they?
Hopefully it won't be needed, but many of our clients live well into their 80s and 90s, so if you think about it, the children could certainly be senior citizens themselves by the time the parents die. So those children who are now senior citizens may benefit from the provisions too. And don't forget, having certain issues of health or even an accident doesn't depend on a person's age.
What about parents of younger children? What type of provisions can protect their families?
We still think about the disability provisions and pray that they'll never be needed. But younger families are usually more concerned about who the guardians of their children will be and who would manage the inheritance.
So who does all of that?
Well, if the parents don't have a will saying who will do it, the court will have to decide what is in the best interest of the child.
I know a judge would use his or her best judgment, but I wouldn't want that for my sons.
Me neither. That's why you should always have a will appointing guardians for your minor children. Another thing that parents are concerned about is how the money will be managed and used for the benefit of their children. Also, when should they just give the money to their children outright and trust them to manage it?
Don't they have a right to all of the inheritance when they turn 18?
Yes, unless your will says otherwise. We rarely see parents who want children to inherit a sum of money outright at 18 years of age, or even 21 for that matter.
So how do you help these families?
First, we need to figure out if the parents have a specific concern. Is the child a troubled teen or an adult with a gambling problem? Or are they really just good kids, but parents know that a big chunk of money could have a bad effect on the child and those around them? Or are they disabled in some way, such as autism or Down syndrome, and we want to be sure not to disrupt Medicaid eligibility?
What are some of the options you can offer them?
One option we see more and more of is special language preventing a child or grandchild from having access to money if there's drug abuse.
Well, that makes sense. The inheritance could not only be wasted on drugs, but also could lead to a drug overdose or even death.
That's right. We've even had parents of very young children ask us to put that language in their wills as a just-in-case sort of thing, but we can also specify how the money can and will be spent.
So I'm sure education would be one valid expense, and maybe healthcare?
Yeah, we usually aim to include anything their parents would have provided, and we use an acronym, HEMS, which stands for Health, Education, Maintenance, or Support.
HEMS, HEMS. That's easy to remember. So with HEMS, the trustee could use the inheritance to provide for the child's health care needs, private schooling, and college. And then maintenance and support would be things like clothing, a roof over their head, maybe a practical car when they become older.
Exactly.
But now you have me thinking. A few years difference in our children's ages really makes a big difference in what they need. I know plenty of families who have an age gap of at least several years between their oldest child and their youngest child. So what if parents had already paid for the oldest child's college and wedding expenses before they passed away, but the youngest child is still in high school? Dividing the estate equally doesn't seem fair to the younger child.
That's right. So using your scenario, what we can do is set up the estate to create what's called a common pot trust for the two sons when the estate is settled. That means the trust isn't created until both parents die, with a younger child of a certain age, such as 23 years old, or whatever age the parents are comfortable with.
So then a trustee who acts like the manager of the common pot trust would use the trust funds for the benefit of both sons, but primarily to give the younger son the same benefits that the older son already had?
That's right, and the inheritance stays in the shared common pot trust until that certain age to give the younger child the opportunity to get his undergraduate degree before we split up what is left into two separate shares for the boys.
So the sons get their inheritance when the youngest one turns 23. Isn't that kind of young still? I mean, especially if we're talking about thousands of dollars and the fact that his parents aren't there to guide him.
Now you're starting to sound like us. We definitely agree. Most of our clients do prefer to say that even though we divide the trust evenly when the younger child turns 23 and there's no more common pot, they still want to keep it in trust for the sons until they reach a certain age, especially since they know the trustee can access the funds for the boys' needs for HEMS.
That's right. And now I have HEMS memorized: health, education, maintenance, and support.
You might not need us much longer for this show. It sounds like you got it down.
Maybe I'm a worrier, but I still don't know if I like the idea of the sons getting their half all at once. I keep thinking about the statistics that say people who have a windfall, like lottery winners, often spend the money quickly and end off in worse financial straits than before they won the money.
That's right. The will can also specify that the children will be able to withdraw the money when they reach certain ages. For example, 10% per year, or maybe a third at age 25, then half of what remains at age 30, and then the right to withdraw the remaining balance at 35. There are many options and a lot of flexibility. The parents may change their mind from this from time to time also.
I like that. I mean, give them each an equal opportunity to get their education and start in their adult life, just like we would as parents. Then split up the money and give them the opportunity to learn how to manage that money before turning it all over to them. Can we do this for our grandchildren as well?
Absolutely, we can.
So now we know the importance of having a well-structured will in the foundation of a good estate plan. But that's just one of the building blocks in our estate foundation. When we come back, Mike and Richard will explain how a power of attorney document shores up that foundation when Elder Care Answers returns.
Welcome home to Shepherd Living at Savannah Quarters. Shepherd Living is unlike anything else. From our greenhouses and farm fresh restaurant to our fully outfitted spa and wellness center, it's all-inclusive wellness resort style living. After all, what good is living longer if you are not living well? Give us a call at 844-8POOLA or stop by anytime, 101 Shepherd Way at the corner of Pooler Parkway and East Haven Boulevard. We'd love to meet you.
Right arm, right leg.
Left leg, left arm.
Both legs above the knee.
Both legs, part of my left hand.
Lost both my legs in Iraq.
These 9/11 veterans are just a few of the heroes we serve at Homes for Our Troops. For nearly 2,000 severely injured veterans, everyday life has become filled with barriers. So we build specially adapted homes with features like wheelchair access, roll-in showers, and pull-down cabinets that allow them to function independently and focus on their recovery and family. This life-changing gift of freedom is provided mortgage-free to these veterans, thanks to our donors and supporters. But we need you to join us too in completing this important mission. Please visit hfotusa.org and help build homes and rebuild lives.
This is what high blood pressure looks like. Talk with your doctor to create a treatment plan that works for you. Go to loweryourhbp.org.
Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Richard, before the commercial break, we discussed important elder law and disability provisions for our last will and testament, as well as ways to structure inheritance for our children or grandchildren. But that's just one of the important estate planning documents each of us as an adult should have, right?
Yes, a person's will doesn't do anything until that person passes away, so we still need certain documents to protect our health and financial decisions while we're living in case we have an emergency or a disability.
Well, I've heard people say that it's all taken care of because they have a will naming their loved one as the executor.
That's a common misunderstanding. The controlling document for financial decisions during a person's life is called the power of attorney. A will doesn't do anything or give anyone power during a person's life. The person appointed by a will to be the executor only has power over the estate once the person has died, we have a death certificate, and the probate court appoints them as executor.
So the power of attorney is the controlling document while a person is living. And I remember there are two types of powers of attorney, one for medical decisions and another for financial decisions.
That's the right idea, but Georgia calls the healthcare document an advance directive and the financial document a durable power of attorney. The durable power of attorney has changed quite a bit over the past decade or so.
What types of changes?
We've seen many financial institutions become wary of accepting powers of attorney if they're old or if they don't have specific elder law and disability provisions.
So we should have these documents updated from time to time?
That's right. You can see why a financial institution would be hesitant to accept a very old power of attorney without the legal protection of knowing that it's still the principal's wishes. People often change their minds. The other issue is that years ago it was okay to say the agent or attorney in fact has certain powers and then say, and anything that I can do. But nowadays we need to be very specific.
Okay, I think I understand, but this sounds complicated. I mean, isn't it just common sense to cover everything by including a phrase similar to, and anything I can do?
That does seem like a common sense provision, and there's nothing wrong with including provisions like that, but it's not good enough for us to rely on. So if you trust your attorney, in fact, to deal with your real estate, to sell it, lease it, mortgage it, transfer it, anything like that, you should say that explicitly.
Okay, so try to cover all of the options, but then still include a general provision in case something unexpected comes up. What other provisions should we be sure are covered in our general durable power of attorney?
Well, gifting is another big issue. People often put limits on the amounts that can be gifted. This is mostly a leftover provision from when we used gifting to protect assets from the estate tax after death.
I can see why people would be motivated to avoid estate taxes. So why do you still say that isn't needed?
In most cases, it isn't needed because less than 1% of us have enough assets that we'd have to pay estate tax. But most of us will have an expensive care need someday. So we need our durable power of attorney to give the attorney, in fact, the power to gift to a person or trust in case we need to do crisis planning.
Crisis planning is what you call it when a person is either in a nursing home or is likely to go into a nursing home in the near future?
That's right. For example, if mom is incapacitated and likely to need nursing home care before she passes away, it may be smart for the attorney, in fact, to move some of her assets to a trust to protect them, while working with an attorney to follow the Medicaid guidelines so that mom qualifies for Medicaid as soon as possible.
And that repositioning of mom's assets is considered a gift. So we don't want to limit the provisions that might help us from carrying out money-saving crisis strategy.
I see, but doesn't that make a person nervous? I mean, giving all of that power to their attorney, in fact, even if it's their spouse or child.
Most people are fine with it, and that attorney, in fact, has what we call a fiduciary duty, which basically means they have to use their powers for good and not for evil. We also have to use self-dealing language.
Self-dealing. Now, what do you mean by that?
We have to say that the person understands that if her attorney, in fact, saves her money or protects her assets, that it could end up benefiting the attorney, in fact, too.
So if my husband is my attorney, in fact, and I'm incapacitated and in a facility, and he decides to sell the house, that could be considered self-dealing?
Yes, we've had that happen in transactions with children and even spouses acting as an attorney in fact.
It does sound kind of silly to have to say something that seems like common sense, but if you are someone's attorney in fact and you're not able to do what you know in your heart is best for them, you wouldn't be happy.
No, I wouldn't. And if my loved one was having a crisis, the last thing I want is somebody telling me I can't do what I need to do to protect them. It seems like things just keep getting more complicated, and this is a lot to remember.
We don't expect our viewers or even our clients to remember all these important points. We can take care of making sure the right provisions are in every document.
But we do want them to understand the importance of having elder care and disability provisions in their documents.
Well, that makes sense. We just need to understand why these provisions are in there. Now, earlier we discussed parents who had minor children and the importance of their last will and testament to provide for who would be guardian of those children and who would manage the inheritance. But what if there was a car accident or something and they weren't deceased, but they were incapacitated for a period of time?
I see where you're going with this, and your instincts are good. There is a special document called a standby guardianship form in which our clients name who they choose as the guardians of their minor children until they're able to care for them again.
Recently, I was looking at some of my IRA paperwork and I noticed my husband is my beneficiary, which is good. But what would happen if he passed away before me?
That's a great question. The IRA would pass to your alternate beneficiary. Sometimes they're also referred to as your secondary or contingent beneficiary.
So I guess that would be my sons?
Maybe. It depends on who you listed on your beneficiary designation forms that you filled out for your IRA custodian.
You may have listed your estate if your sons were still minors at the time you completed the forms. Many people just list their estate, which means it would go through their will and the entire probate process.
That would be good since I could use my will the way we discussed in our first segment, because in my will I can specify how and when my sons would have access to the IRA, right?
Well, yes, having the proceeds of your IRA go through your estate would enable you to control how and when your kids get that money, but it could end up being a poor tax outcome.
Why would that create a higher tax liability?
Because soon after your death, your IRA would have to be cashed out to have the funds distributed to your estate. Traditional IRA funds haven't been taxed yet, so that means when they're cashed out to pay your estate, it's essentially income to your estate all in one tax year.
Well, that sounds terrible. How can we avoid that?
Well, if your sons are all adults, you could just name them as your alternate beneficiaries.
Then they'd inherit it all at once as an IRA and not have to pay taxes all in 1 year?
Legally, they could leave the money as an IRA and wouldn't have to pay the taxes until they withdraw the funds. That'd be the smart thing to do.
But many financial advisors tell us the typical beneficiaries, especially younger beneficiaries, don't exercise the best judgment and end up cashing out the IRAs relatively quickly.
I don't like that. My husband and I have worked very hard to build these investments.
We can actually create a retirement trust that keeps the IRAs from being cashed out too soon. And the retirement trust protects the money from creditors, divorce, or other bad things that could happen. Like we always say, bad things can happen to good people.
Well, it sounds like the ideal solution. Provide the IRA inheritance to the children in a way they can benefit from it for years to come, while protecting it as much as possible for the unexpected things that happen.
Exactly. That's why the retirement trust has become a very popular trust for many of our clients. They love the idea that they can provide this type of legacy for their children or even grandchildren.
They often tell us that they worry that benefits such as Social Security may not be around for their children, so the idea of creating a source of income that could last for years sounds pretty exciting.
It sounds like they would be creating a pension then.
Right. It does sound similar to a pension, but of course it isn't exactly a pension. It creates a right to the required minimum distributions for the IRA for as long as current law permits or the IRA funds last. The parent can decide if and when the beneficiary can get to more funds from the IRA, and it has some protections from creditors, divorces, and bad decisions.
Okay, but what about while the original owner is still living? I wouldn't want to lose control of my IRA while I'm living. I'm counting on that money for my retirement.
That's the best part. Nothing changes while you're living. The trust is just beneficiary once you pass away. You could say it's on standby until it's needed. It can even stay with the same custodian, meaning it can stay with the same financial advisor too.
I can't imagine why everybody wouldn't want a retirement trust. It sounds like the perfect solution no matter what age your child is. Well, now we understand the benefits of a retirement trust and the importance of power of attorney documents. When Elder Care Answers returns, Mike and Richard will explain how to navigate the probate process. Stay with us.
Welcome home to Shepherd Living at Savannah Quarters Memory Care Community. You've spent a lifetime together. Why should that change now? Maintain your independence and lifestyle while still remaining there for your loved one with Alzheimer's. Secure all-inclusive care within our Savannah Quarters Senior Living Resort community. Give us a call at 844-8-POOLA or stop by anytime at 101 Shepherd Way, next door to our independent and assisted living community. We'd love to meet you.
Patriotism. It inspires passionate debate. It's worn like a badge of honor with good reason, because it means love and devotion for one's country. Love. But what really makes up this country of ours? What is it we love? It's the people. Almost half the country belongs to minority groups. People who are lesbian, African American, and bi and transgender and Native American, and proud of it. After all, what's more American than freedom to celebrate the things that make us, us? This year, patriotism shouldn't just be about pride of country. It should be about love. Love beyond age, disability, sexuality, race, religion, and any other labels. Because the second any of us judge people based on those labels, we're not really being patriotic, are we? Because love has no labels.
Welcome back to Elder Care Answers. We've been talking with elder care and estate planning experts Michael Smith and Richard Barid regarding the building blocks of a good estate foundation. Mike, we've mentioned probate a couple times today, but we really haven't discussed exactly what probate is. Can you tell me a little more about it?
Sure. Probate is the legal process to settle your estate when you die. Once you pass away, your executor begins that process by officially notifying your legal heirs, then submitting your last will and testament, your death certificate, and a petition to probate your will to the county probate court.
Is that it then? The executor just needs to notify the heirs and file the proper forms to the county probate court?
Unfortunately, that's just the beginning of the process. Once all that's completed, a hearing is scheduled to swear in the executor, and then an ad is run in the local paper so that all of your debtors and creditors have notice that you passed away.
And then we're done?
Not quite. After 4 weeks of notices, we still have to wait another 90 days for creditors to make a claim, even if you don't think there are any creditors.
So it sounds like probate is going to take at least 5 to 6 months?
Yes, it varies by county, but we often see it take months to have the executor appointed and then another 5 to 6 months for the estate to be distributed.
I didn't realize it would take so long, and I can't imagine spending so much time to settle my loved one's estate. I feel like it would be really stressful.
Exactly. You're not alone. Most people don't realize that either.
What if I don't have a will? Is that even more difficult?
It's a little more difficult because we don't have your wishes written down in a legal document, so the probate court has to appoint an administrator to go through the process, and all the decisions are going to be based on state law.
So state law determines who my beneficiaries are?
That's right. Most people don't know that if you die without a will and you're married and have children, that your spouse doesn't just inherit everything. The assets are divided up between your spouse and your children, with your spouse receiving as little as 1/3 of the assets.
Wait, my husband doesn't just get everything? I mean, we've worked together to build our estate, and I would never want that to happen to him.
Then make sure you have a will.
That's for sure. So what happens to all of that information regarding my estate?
It becomes part of the public record, sort of like a deed.
It's not that I have anything to hide, but I really would prefer for my private matters to remain private. I don't like the idea that just anybody could read my will or see a list of my assets.
We actually hear that a lot, and that's why for many of our clients, a revocable living trust is the answer. It can replace your will and it avoids probate. But I think that's a topic for another day.
Yeah, this is a little overwhelming. This sounds like a lot for the average person to do along with our other responsibilities in daily life. Does your office help with probate?
Sure. Our office can assist the executor as much as they would like. Some want us to do all of the work, while others just need a little bit of help. It's often comforting to the executor to at least have a probate consult with our office before they start the process, so we can walk them through it.
Mike and Richard, you've certainly given us a lot of really helpful information today. Thank you for walking us through this sometimes complicated process.
Happy to help.
You're welcome.
So now you can get help building the foundation of your estate plan by contacting Mike and Richard's office at 912-250-5181. You can also visit their website at smithbarid.com/info. While you're visiting their website, you can request an appointment, read their blog, and find other valuable resources. And follow Smith Barid on Facebook, LinkedIn, Pinterest, and Twitter. There's always new information being posted. Thank you for joining us today, and we'll see you next time on Elder Care Answers.
Welcome home to Shepherd Living at Savannah Quarters. Our chefs are serving up fresh, locally sourced goodness from southern farms and shores, paired with inspiration from around the globe. Share a meal with us today, or better yet, make Shepherd your home and call our kitchen your kitchen. Discover the joy of stress-free wellness resort-style living. Give us a call at 844-8-POOLA or stop by anytime at 101 Shepherd Way on the corner of Pooler Parkway and East Haven Boulevard. We'd love to meet you.